Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And this week's contract tip has to do with identifying a closing attorney as the holder of the earnest money on the GAR purchase and sale agreement. Now, I have addressed this issue before in general regarding having a closing attorney as the holder of the earnest money, and I'll identify the previous videos on that issue down below. In the GAR purchase and sale agreement, which is Form F20, where the parties identify the holder of the earnest money, that is in paragraph A5. It says holder of earnest money, and you fill in the blank and you identify the holder of the earnest money. Now, if the parties do choose for whatever reason to identify a closing attorney as the holder of the earnest money, there are two additional forms that are required to go with your contract. Form F84A must be attached as an exhibit of the offer, and then 84B must be signed by the closing attorney, either simultaneous with the offer before you go binding or within a certain amount of time after you go binding. So there are a lot of issues with having a closing attorney identified as the holder of the earnest money. First of all, if you do not get a closing attorney to sign off on agreeing to be the holder of the earnest money, then don't put down an attorney to hold the earnest money. Nowhere in the actual purchase and sale agreement on GAR, or in the RE forms for that matter, do they sign the contract. They're not a party to the contract. You can identify them all you want, but if they don't sign, then they don't have to fulfill any of those responsibilities as outlined in the contract that you have that discussion about with your buyers and your sellers. So the GAR Contract Forms Committee, 2 years ago, they identified there's a form that they created for the closing attorney to sign, agreeing to fulfill the responsibilities of holder of the earnest money with respect to what's identified in the purchase and sale agreement. Then last year, or actually this year, they came up with another form because buyers and sellers were not always able to get the closing attorney's signature before they went binding. So now there is Form F84A and F84B. But again, the holder of the earnest money, there are a number of responsibilities that are outlined for that position within the contract. Starting on paragraph B5, holder of earnest money. One of the first things the holder has to do is make the deposit, and if they don't receive the earnest money from the buyer, or the earnest money bounces, is not honored by the bank, then the holder is required to send notice to the buyer and the seller so that the buyer has a time frame to cure, and then the seller has termination rights. So, and there's a lot more to it, but there's a lot going on identified in the purchase and sale agreement. So let's look at those exhibits. So Form 84A is closing attorney acting as holder of earnest money exhibit. Again, this form is created so that a buyer and a seller may go binding on a purchase and sale agreement even if they don't at this point have the closing attorney's signature agreeing to be the holder. So in this exhibit, it does state you do identify the closing attorney that would be the holder, and it does state that the holder must sign the other form, F84B. They must sign agreeing to be holder and fulfill all of those responsibilities as outlined in the purchase and sale agreement within 3 business days of the binding contract. They must sign the agreement to serve as holder and deliver that signed agreement back to the buyer and the seller, all within 3 business days of the binding agreement. The buyer must deliver the purchase and sale agreement to the closing attorney within 1 business day of going binding. If they don't, guess what, everybody? The buyer is in default. So the buyer shall be, if the agreement isn't easy for me to say. If the buyer doesn't deliver the purchase and sale agreement to the closing attorney within 1 day, buyer shall be in default of this agreement. If buyer fails to timely deliver the agreement or any agreement thereto within 1 business day, such default, guess what, gives the seller the right to terminate. Then it also states on this exhibit, and again, this is an exhibit for the buyer and the seller when you go binding. So the closing attorney has not signed this form yet. Failure of the closing attorney to timely agree to become the holder. So if the attorney doesn't agree to become the holder or doesn't do it within the time frame, then the alternate holder automatically becomes the holder. So then paragraph 5, and this is really the point of this video. Agents, when you guys, if for whatever reason you identify a closing attorney to be the holder of the earnest money, you absolutely must fill out paragraph number 5 on form F84A. You must identify an alternate holder, which must be one of the brokers, either the selling broker or the listing broker. It says, buyer and seller agree that in the event the closing attorney does not become the holder, the following alternate holder, who shall be a real estate broker in this agreement, shall become the holder. The alternate holder hereby agrees to immediately serve as holder pursuant to this agreement. In this transaction, the alternate holder shall be blank, and you identify, again, either the listing broker or the selling broker. The signatures of the alternate holder, so forth and so on. Then the other part of this form, well, it's a separate form, it's a part B, is form F84B, agreement of closing attorney to serve as holder of the earnest money. This is the actual form that the closing attorney must now sign, where they agree to fulfill the responsibilities as outlined in the purchase and sale agreement. And then it reiterates all the information from the exhibit. It says closing attorney must agree to become holder within 3 business days of the binding agreement date, and then get this signed form back to the buyer and the seller within that time frame. And then it also reiterates what I just went over. Failure of closing attorney to timely become holder. If the closing attorney named as holder herein has not become the holder within 3 business days, the alternate holder referenced in the closing shall become the acting holder of the earnest money and automatically becomes the holder instead of the closing attorney. All parties consent, and the earnest money is transferred to the holder, and all parties shall cooperate, so forth and so on. So here's the issue. The issue is selling agent and listing agent. If you guys do not identify one of your brokers to be the alternate holder of the closing attorney, then what happens is you are putting the buyer in a potential default of the contract with no remedy to cure that default. So if the closing attorney fails to sign within the time frame, or if the buyer fails to get the purchase and sale agreement to the closing attorney within the time frame, then the buyer is in default. It's already identified in that exhibit. It stated that. If you do not identify an alternate holder, there's no remedy for that buyer's default. What if the closing attorney doesn't agree to hold the earnest money? So you must fill out an alternate holder. Additionally, if you do not fill out an alternate holder, and for whatever reason, the closing attorney never signs to agree to be the holder, earnest money is never deposited, notices are never given, so forth and so on, you have a contract that fails. It is unenforceable. You have not demonstrated potentially a meeting of the minds, or it could be deemed voidable. Regardless, you guys now, as being well-trained, educated real estate agents, looking out for your client's best interests. Number 1, please consider having the listing broker or the selling broker as the holder of the earnest money. Your brokers hold a real estate license and are beholden to license law, which GREC enforces. A closing attorney, if they don't have a real estate license, GREC has no jurisdiction over anything having to do with their license. Now, obviously, there are laws in place regarding money, but they're not a party to the contract if they don't sign anything. But if you do identify a closing attorney as the holder of the earnest money, you absolutely must use forms 84A and 84B, number 1, and number 2, you absolutely must identify the listing broker or the selling broker as an alternate holder of the earnest money. Now, again, these are all with respect to the GAR, Georgia Association of Realtor contract forms. I hope this contract tip helped you out. If you do go binding on the RE forms, same thing applies. There aren't the specific forms that GAR has, but if the parties identify a closing attorney as the holder of the earnest money, again, keep in mind, there's nothing that the closing attorney signs agreeing to be the holder of the earnest money. So just keep those tips in mind. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.